Picture a Saturday morning in late spring. You've been planning this road trip for weeks. The car is packed, the kids are buckled in, and everyone is in a good mood. You cross a state line somewhere around lunchtime and pull off at a gas station to stretch your legs. You don't think twice about it, but you have a legally owned handgun locked in your center console, registered, and perfectly lawful back home. What you didn't look up before you left is that the state you just entered has a completely different set of gun laws. Not slightly different, completely different ones. And that one stop, that one moment of not knowing, could turn a fully law-abiding citizen into someone facing serious criminal charges before the day is over. Stay with this video because the gap between what people believe gun law says and what it actually says in practice is wide enough to change someone's life. By the time we finish, you're going to understand not just the basics of the Second Amendment, but the real-world picture. How it plays out in vehicles, across state lines, in public spaces, and during encounters with law enforcement. That kind of understanding is what keeps good people out of bad situations. That's worth the next 20 minutes of your time. The most widespread misunderstanding about gun rights in America goes something like this. People believe the Second Amendment is a national permission slip. They think it means you can own a gun, carry a gun, and use it in defense of yourself and your family wherever you happen to be, because it's a constitutional right. The logic feels completely solid. If it's written into the Constitution, it applies everywhere, to everyone, in every situation. That belief is understandable. But the legal reality on the ground is far more complicated than that, and the gap between the belief and the reality is exactly where problems happen. Constitutional rights are real. They matter. But they don't exist in a vacuum. They operate inside a legal system with multiple layers. There's federal law, there's state law, and there are local ordinances. And they don't always point in the same direction. The Second Amendment sets a floor. It tells the government it cannot simply erase your right to keep and bear arms. But it doesn't prevent all regulation. Courts have said that plainly and repeatedly at the highest levels. Think about it like free speech. You have the right to speak freely, and that right is genuine and protected. But you can't threaten someone and call it free speech. You can't defraud people with false statements and claim the First Amendment shields you. The right exists, and it has real teeth. But it also has edges. Gun rights work the same way. The right is real, and courts have affirmed it clearly. But it has edges too. And the frustrating part is that those edges are drawn differently depending on which state you're standing in. Most people never run into those edges because they stay close to home, they follow the rules they already know, and they don't think much about how things might change 100 miles away. But if you travel, if you cross state lines, if you carry regularly, or if you live near a border, those edges stop being abstract very fast. And the painful truth is that most people don't know exactly where they are until they've already crossed one. Now let's talk about the gap that causes the most real-world trouble. Picture two people, same background, same responsible habits, same firearm. One of them lives in a state that allows permitless carry, which means no permit is required to carry a concealed handgun if you're legally allowed to own one in the first place. The other lives in a state that requires a permit, a training course, an additional background check, and approval from a local authority before they'll let you carry outside your home. Both of these people believe they're following the rules. Both of them are probably right for their own state. But if either one drives into the other state without checking what the rules are there, something can go very wrong very fast. That's what could be called the two worlds problem. There's the world people imagine gun law to be, where the Second Amendment applies uniformly coast to coast, and owning a gun legally in your home state means you're legal everywhere you go. And then there's the actual world, where a firearm that's completely lawful in your driveway can be a criminal matter 50 miles past the state line. That gap isn't a technicality buried in fine print. It's a real-world trap that catches real people who thought they were doing everything right. And it's not just carry rules, it's magazine capacity limits. Some states cap how many rounds a magazine can hold. A standard factory magazine for a common handgun might be totally fine in your home state and banned outright in the next. It's rules around suppressors, which are regulated under federal law, but treated differently by states on top of that. It's restrictions on certain firearm features like adjustable stocks, certain barrel lengths, or pistol grip configurations that are completely unremarkable in one place and prohibited in another. The patchwork of rules across 50 states is real, and it affects ordinary people doing ordinary things all the time. The frustrating truth is that most of the people who get caught in this patchwork aren't dangerous. They're not reckless gun owners looking for trouble. They just didn't do the research before they traveled. They assumed the rules would follow them because they were following the law at home. That assumption is completely understandable. It's also one of the more expensive mistakes a gun owner can make, and it happens more often than most people realize. To understand why the landscape looks the way it does, you have to understand how gun law in this country actually got here. For most of American history, courts avoided making clear rulings on what the Second Amendment protected at the individual level. Many lower courts read it as a right tied to organized militia service, meaning it wasn't really about an individual's right to own a gun for personal use. That left the government with wide room to regulate firearms, and states used that room in dramatically different ways. Some kept things very permissive, others built up layers of restrictions over decades. Then in 2008, a case reached the Supreme Court that changed everything. It involved a man named Dick Heller, a special police officer in Washington, D.C., who wanted to register a handgun and keep it at home for self-defense. D.C.'s laws at the time made that essentially impossible. The case went all the way to the top, and in District of Columbia versus Heller, the Supreme Court ruled for the first time in plain terms that the Second Amendment protects an individual right to own a firearm for traditionally lawful purposes, particularly self-defense, inside the home. That was a seismic shift. For decades, courts had been reluctant to say it that directly, and gun rights supporters had been waiting for exactly that kind of clarity. But Heller came with a significant caveat. The court was very clear that the right is not unlimited. The ruling specifically said that certain regulations are still entirely lawful. Prohibitions on felons and people with serious mental illness owning guns. Restrictions on carrying firearms in schools or government buildings. Conditions and qualifications on the commercial sale of firearms. These kinds of regulations, the court said, are consistent with the right and don't threaten it. So the decision opened an important door. It just didn't swing it all the way open, and it left a lot of questions unanswered about what comes next. Those unanswered questions kept piling up until 2022, when another landmark case reshaped the terrain again. New York had a system for issuing carry permits that required applicants to demonstrate what the state called proper cause. That meant you had to show a specific individual reason beyond general self-defense to get a permit to carry a firearm outside your home. The case challenging that system, New York State Rifle and Pistol Association v. Bruin, made it to the Supreme Court. The court struck New York's proper cause requirement down in a 6-3 decision. The reasoning was direct. The government cannot require you to justify why you want to exercise a constitutional right before they let you do it. You don't have to prove you need to speak before you speak. The same standard should apply to carrying a firearm. The Bruin ruling hit several states immediately. New York, California, New Jersey, Maryland, and others had similar permit systems and were forced to revise them. But the decision's bigger impact came from the new legal test it established for evaluating gun laws. Before Bruin, courts would weigh the government's interest in safety against the burden a law placed on gun rights. After Bruin, courts are supposed to ask whether a gun law fits within the historical tradition of firearm regulation in America. That sounds like a clean standard. In practice, courts have been wrestling with what it means, applying it in different ways, and producing conflicting results. The Supreme Court has continued to take up related cases to refine it. This area of law is genuinely still unsettled, and that matters for everyone who owns or carries a firearm. If you want to be part of a community that follows these developments closely, not just the political back and forth, but the actual legal shifts that affect what you can do on any given day, this channel is worth subscribing to. The people here aren't looking for outrage fuel. They're looking for real understanding. They want to know what changed, what it means, and what to do about it. That's what we focus on here, and that kind of conversation is worth showing up for. Now let's get into the part that touches everyday life the most directly, where law-abiding gun owners actually get into trouble. Traveling across state lines with a firearm is probably the single area where well-intentioned people make the most mistakes. There is a federal law called the Firearm Owners Protection Act, commonly shortened to FOPA, which includes a safe passage provision. In plain terms, it says that if your firearm is legal in your starting state and legal in your destination state, and you keep it unloaded and stored in a locked container that's not easily accessible from the passenger area during the drive, you're protected when passing through states in between that have stricter rules. That's the core of it. But safe passage has limits that catch people off guard. The protection is designed for continuous travel. If you stop overnight in a state with restrictive laws, that protection becomes significantly shakier. Some jurisdictions have prosecuted travelers for stops that lasted more than just a fuel or food break, arguing the person was no longer simply passing through. Counting on federal safe passage as a full shield without understanding those limits is a gamble that some people have lost in court. The safer move is to look up the rules of every state you're entering before you go, not just the state where you're ending up. Vehicles are their own complicated category. Most states have specific rules about how a firearm must be stored or positioned in a car, whether it needs to be unloaded, whether it has to be in a locked hard case, whether it can legally be in the passenger compartment at all. If you have a concealed carry permit, many states extend those permit privileges to your vehicle, but the specifics still vary quite a bit. In some states with an active permit, you can keep a loaded firearm in the center console. In others, there are restrictions on where in the vehicle it can sit even with a valid permit. And in states that have moved to permitless carry, the vehicle rules generally align with that, but aren't always identical. Know your state's vehicle rules before you ever need them. During a police encounter, whether it's a traffic stop or anything else, the single most valuable thing you can do is keep things calm and predictable. Officers are trained to pay close attention to movement, especially near the midsection and the lower portions of the vehicle interior. If there's a firearm present, surprise is the last thing you want. Some states have what's called a duty to inform, which means you're legally required to tell an officer you're carrying, or that there's a firearm in the vehicle when they make contact with you. Other states don't require you to volunteer that information unless the officer asks directly. Know which category your state falls into before you're ever in that situation, because learning it during a stop is the wrong time. If you decide to inform an officer, or if you're required to, do it with your hands visible, your voice steady, and your language clear. Tell them where the firearm is. Tell them you won't reach for it without direction. Then ask them how they'd like to proceed from there. That sequence is calm, it's cooperative, and it removes the element of surprise from the situation entirely. Surprises during traffic stops benefit no one, and removing that risk is squarely in your control. Public carry has changed more noticeably than almost anything else in the years since the Bruin decision. More states have had to shift from discretionary permit systems to standard ones, where you can't be denied a permit simply because an official decided you didn't have a compelling enough reason to carry. But even in states that have moved toward more permissive systems, carry is not unrestricted. There are still locations where carrying is prohibited by law regardless of whether you have a valid permit. Schools, courthouses, police stations, polling places, and government buildings are standard examples. Many states add hospitals, bars, and houses of worship to that list. Some allow private businesses to post clear notice that firearms are not allowed on their premises, and in those states, ignoring that notice while carrying can rise to the level of criminal trespass. Know the specific list for the state you're in. It's not long, but getting it wrong has real consequences. Private property is where people sometimes convince themselves that their rights override someone else's rules. They don't. A homeowner, a business owner, a landlord, all of them have the right to set the terms for what happens on their property. The Second Amendment protects your right to own and carry a firearm. It doesn't compel a private party to welcome that firearm onto their property. If a business posts a no firearms sign, the lawful response is to either leave the firearm secured in your vehicle before entering or to choose a different business. It isn't to walk in anyway because you have a permit. Respecting private property rules is both the legal path and the sensible one. Background checks are a piece of the framework worth understanding clearly. Any purchase from a federally licensed dealer requires a background check run through the National Instant Criminal Background Check System, which most people know as NICS. That system screens for the categories of people who are legally prohibited from owning firearms under federal law. The list includes people convicted of felonies, people convicted of certain misdemeanor domestic violence offenses, people under qualifying restraining orders, and several other categories. State law can add to that federal list. A number of states also require background checks for private sales between individuals, meaning sales that don't go through a licensed dealer. Others don't require that. Knowing what your state requires isn't just legally smart. It protects you from unknowingly being part of a transfer that creates legal problems for you or the other person. Red flag laws, which are formally called extreme risk protection orders in most states, have become a significant part of the legal landscape over the past several years. More than 20 states now have some version of these laws in place. They allow a court to issue an order temporarily removing firearms from someone who is found to pose a credible danger to themselves or others. The specifics differ a lot from state to state. Who is allowed to petition the court for an order, what standard of evidence is required, and how quickly the subject of the order can challenge it all vary. Courts have generally upheld these laws when they've been challenged on constitutional grounds, though litigation is ongoing and the details continue to evolve. If you live in a state with one of these laws, understanding how it works is a reasonable part of being a responsible owner. Safe storage is another area where the law is moving in a clear direction. For most of American history, how you stored your firearms at home was entirely your own business. That's changing. As attention has grown around accidental shootings involving children and around theft as a source of guns used in crimes, more states have moved toward requiring secure storage under certain circumstances. Some of those laws focus specifically on households with minors present. Others are written more broadly. The standards and penalties differ, but the trend is consistent. Storing your firearms securely isn't just the responsible thing to do. In a growing number of states, it's becoming a legal obligation. Let's pull all of this together in a way that's actually useful going forward. The Second Amendment gives you a genuine, legally recognized right. Courts have confirmed that at the highest level. But that right doesn't exist outside the law. It lives inside a legal structure that operates at the federal level, the state level, and sometimes the local level. And those layers don't always agree. The right doesn't mean the same thing in every state. It doesn't mean the same thing it meant 5 years ago in some places, and it won't mean exactly the same thing 5 years from now. That's not a reason to be discouraged. It's a reason to stay informed. The most common mistake that responsible gun owners make is assuming that because their intentions are good and their habits are careful, nothing can go wrong. That assumption doesn't hold up. A person can be genuinely responsible, thoughtful, and law-abiding and still end up in a serious legal situation because they didn't know one specific rule in one specific place on one specific day. Ignorance of the law isn't a legal defense, and it's not a practical shield either. Knowledge is part of responsible ownership. It always has been. Build a few habits that become automatic. Know your own state's laws in real detail. Not just the general idea, but the specifics. Where you're permitted to carry, how vehicle storage rules work, what your state requires around secure storage, whether you have a duty to inform law enforcement during an encounter. Those aren't obscure facts buried in legal code. They're the operating rules of your daily life as a gun owner, and knowing them protects you. When you travel, treat firearm laws the way you treat currency or road rules. They change when you cross a border, and assuming otherwise is a mistake. Look up the rules of every state you're entering before you leave. Use reliable sources like your state's Attorney General website or a licensed firearms attorney in the states you're visiting. The Firearm Owners Protection Act gives you meaningful protection during interstate travel, but it's a tool with conditions, not a blanket guarantee. When you deal with law enforcement, remember that calm and clear is always the right posture. Not because you're giving up anything, because a calm and clear interaction protects everyone in it, including you. The roadside is not the place to assert that an officer is wrong about the law, even if they are. That conversation happens later, with a lawyer, in a setting where evidence and argument actually have weight. Keep your hands where they can be seen, say what you're doing before you do it, and keep your explanation short. Those habits serve you in every encounter. Stay current. This is an area of law that is genuinely active. Court decisions are still being made. State legislatures are adjusting their rules in response to court rulings. What was an accurate description of your state's law last year may have been amended since. The best gun owners treat staying informed the same way they treat any other skill. It requires regular attention, not just a one-time review. Subscribing to this channel is one practical way to stay ahead of that. When something significant changes in how gun rights are interpreted or enforced, you'll have the context to understand it before it ever becomes relevant to you personally. That kind of head start is low effort and high value. Come back, bring your questions, and let's keep building that understanding together. The Second Amendment is one of the most contested, most discussed, and most frequently misunderstood parts of American law. That's unlikely to change. But confusion about it doesn't have to be your starting point. You can understand the right clearly, know where its edges are, and make smart, lawful, safe decisions every single time. That's the real goal here. Own it responsibly. Know the rules that apply to you, and keep that knowledge current because the law will keep moving whether you're watching or not.